ordinance which the government has brought in respect to enemy property law, they tried to amend Enemy Properties Act 1968 with effect from 1968 in 2016 or 17. The government is trying to retrospectively amend the entire law, where the provisions of the enemy property, the vesting under the enemy property will be permanent from 1968, though the provision earlier was that the vesting is only for the purposes of preservation and management and control. And by way of this operation, the government is trying to take away the fundamental right of those people who had right between 1968 to 79. A government has stopped the customary rights and the rights to inherit the properties, which is also not correct. Once somebody dies, the properties etc., the estate is to be inherited by his or her legal heirs or successors. Any property or any right over the property, these properties might have been transferred in between 1968 to 2016 or 17. Those transfers will also will be null and void without any opportunity of hearing to the person or without any notice to that person, which is completely against the principle of natural justice as well as the settled law by the courts. Any property, even if the competent court has decided and adjudicated upon, and the central government was a party, and they have admitted the position that enemy property, the enemy or his legal heir or successor has a right to transfer those properties. Those properties are also they are trying to take away. The definition itself of the enemy property has been amended retrospectively, where now even Indian citizens who are the legal heirs or successors of the enemy will also be covered under the definition of enemy, which is very objectionable. You can't treat an Indian citizen as an enemy of the country. Under section 18B of this new ordinance, which the government is proposing to insert in the old act, the effect of this 18B, section 18B would be that any person and every person will be barred from approaching the civil court. The only remedy is given under this new amendment is to approach the central government if there is an order by the central government under section 18. If a person has bought the properties in between 1968 to 2016 from a person who had right to transfer the properties, the buyer has paid the full consideration, the buyer has paid the full stamp duty to the government, he will lose the property without any fault, and he is not even given any opportunity of hearing or any recourse to approach the civil court. The central government or its officer cannot be, because they are not under the oath, they cannot adjudicate upon the civil matters which only the civil court is competent to. They cannot bar in any case, because 226 and 32 articles are there to protect. The government has no right, because these are constitutional provisions. The government has no right to take away those provisions. But the question is, there should be a proper adjudication at the initial stage, because these courts under 226 or 32, whatever rights you are giving, those rights under those provisions, the question of facts cannot be looked into by these courts, apex courts. And the courts are so burdened as on today, then the appeal to High Court and the under section 18B is not a proper remedy, because unless there is a proper adjudication, where is the question of an appeal? These are few aspects which I understand is very clinching and against every settled law of India and against the constitution as well. I have seen in several news channels and all that everybody is talking that this is only against the Muslims or minority communities. This is not only against the minority, because large chunk of people, whoever might have some interest in those properties, will be affected. Suppose a property is sold legally and validly by a legal heir of an enemy, or by a person who was competent to sell the property, which was an enemy property during this period, means 1968 to 2016. If the person has sold the property, taken consideration, gone away, now the buyer, who is a bona fide buyer, paid full consideration, paid full stamp duty, and is a recorded owner, you are taking away the rights of the buyer without giving an opportunity of hearing or without any notice. Even if we leave the first ordinance which came in 2010, in 2006, between 2006 in 2016, this is the fifth ordinance in line, which is the government does not have any power to promulgate to re-promulgate an ordinance, as the Supreme Court has decided. So 7 judges of the Supreme Court bench decided in Krishna Kumar's case. The Supreme Court has categorically said that re-promulgation of an ordinance is fraud on constitution. Promulgate ordinance is an emergent power or emergency provision which can be exercised when the houses of the parliament are not in operation, in session. Now, in view of even that judgment, all these ordinance has no value and should be either withdrawn by the government immediately, or should be or will be struck down by the courts.